with the probe into the Lakhimpur Kheri violence and has in fact suggested setting up an independent committee under 2 retired judges. To help us understand what the court has said, what the implications of this are and what are the options in front of the Uttar Pradesh government, we have with us Bhadra Sinha, who as you know tracks courts for us and has been tracking this case very closely. So do start sending in your questions for government matters. Bhadra, so the last time in fact we'd spoken about the case when it came to the court, and we were discussing what the Uttar Pradesh government is likely to do before the next hearing. So from then to now, if you can just tell us what has happened, what the UP government submitted in court and why the court has said it's unhappy.
See, Ruhi, as you said, on the last date of hearing, which actually took place on 20th of October, the court had expressed its displeasure over the way the progress was made in the case, and it had actually told the UP Government Council Senior Advocate Harish Salve that the court probably thinks that the state police is dragging its feet over the probe. And then also it had pointed to certain lacunae in the way the matter was being investigated, and it had given out very specific directions to the UP government to make sure that the witnesses are protected, and those vulnerable witnesses, their statements are recorded under section 164 of Criminal Procedure Code, which actually means that the statements are recorded before a magistrate and not just merely before the police. So after pointing out these lapses, the court had given like about 10 to 12 days to the UP government, to the UP police to proceed further, and in the way the court expected them to proceed. But today when the hearing commenced, at the outset itself, the Chief Justice of India, Justice N.V. Ramana, made the bench's displeasure very clear and said that the progress is not the way as was expected by the bench. And during the hearing, which proceeded for almost 20 to 25 minutes, they once again pointed to the lapses in the way the police was probing the incident, and they then went on to suggest, rather indicate, that they would like to, they would like to appoint a former retired Punjab and Haryana judge to monitor the probe, because they have actually there are multiple concerns which were raised during the hearing. See, the problem is, Ruhi, as all of us know, that the entire incident, the violence, out of the violence, there were 2 cases that emerged. One was related to the mowing down of the farmers by the car, that the farmers were crushed to death. And the second was the retaliatory violence. So in a way, cross cases have been registered in the entire incident. And the major concern which was expressed by the court today was over overlapping of the evidence, because the court felt the evidence recorded in the second FIR, that is related to the retaliatory violence, the court felt that the evidence and the statements that were recorded in the FIR are probably or possibly could help the prime accused in the accident case, which is the first FIR, which is in which the farmers were killed. And they very categorically told Mr. Salve that these 2 cases have to be treated independently. The evidence collected in the second case cannot be used as a defense evidence in favor of the accused in the first case. And that is why they somewhere felt that this needs to be probed by an independent person, probably by a person who doesn't belong to that state, because as we know, the prime accused in the accident case is actually the son of a central minister who probably hails from that area. And that is the reason why the bench suggested the name of a retired Punjab and Haryana High Court judge.
Right. So, Bhadra, what role, if this committee is indeed set up, what role is it going to play? It has to monitor the probe. So, what are the parameters going to be? And will the committee be set up, or is there another step before that's decided?
So as was indicated by the court today, the judges are of a view that an independent judge or an independent committee should monitor the probe, but it has given a chance to the UP government to come back. If UP agrees to it, accepts the court's suggestion, then no formal order would be required. But if it doesn't, then of course the court will have to pronounce a formal order in it. As far as the parameters are concerned, the court is very clear on the conduct of the committee, the task which would be given out to the committee, and that is to ensure that there is no overlapping of the evidence in the 2 cases. The 2 cases proceed independently, and evidence in one case should have no bearing on the other case. So, to kind of weed out the confusion which is right now emerging as accepted even by the UP Government Council, to weed out these confusions, so that the probe is unbiased, impartial and fair.
Right.
So basically to infuse independence in the probe of both the cases, since there are counter allegations, the court wants this independent committee to set up.
Right. Now, Bhadra, in the previous few discussions that we've had, we've repeatedly had this one question that's asked, and I'm preempting those questions even today. We, in fact, had this discussion even when we had the Pegasus conversation about a committee being set up on whether the judiciary is overreaching, whether it's stepping into the domain of the legislator and the executive. So, is this a fuzzy area as far as today's order
See, Ruhi,
concerned?
as far as this is concerned, today during the hearing, one of the members of the bench, Justice Suryakant, very specifically said that, we are not looking at the merits of the evidence. We are just trying to make sure that the investigation is impartial. So see, the court is not seeing as to what kind of evidence has been collected or what is the nature of the statement given by the witnesses. But they are trying to, create a balance to make sure that, in both the FIRs, justice is served. Because they don't want that while investigating the first case, the victims of the second case get ignored,
right,
or vice versa. So to ensure independence in both the cases, they are, they have resorted to this suggestion. But as far as intervention is concerned, I don't think that in this particular case they're really intervening, because they're staying away from the nature of investigation. They are not, getting into the nitty-gritties of what kind of evidence has been collected, whether the CCTV footage is correct or not, whether the CDR, that is the call detail records, whether they are perfect or not. But yeah, they are trying to make sure that the probe is impartial, and that the probe is done in a right way. They are not really, I wouldn't say that they are leading the probe, but they're simply ensuring that it is being done in the correct manner, so that, it is made sure that justice is served and it is at least seen to be served.
Right. Okay, this question is from our viewer Roli. What lapses has the court pointed towards in the probe so far?
Yeah, see, on the last date of hearing, the court had pointed out how the police had ignored recording of statements of vulnerable witnesses, and how the police had actually not given out them proper protection under the Witness Protection Act. Anyways, that was subsequently done by the UP government after an assurance was given to the court. Now, as far as today is concerned, they pointed out a very interesting aspect in the entire investigation, that is as the seizure of cell phones. In the sense that there are 13 accused, as per the UP Government Council submission, there are 13 accused, but the police has seized the cell phone of only one accused, and that is Ashish Mishra. So the court asked a very simple question, that what about the other accused? Why didn't you seize their phones? So to that, Mr. Salve's answer was that, the other accused claimed that they have thrown away the phones. And to kind of cover up that, or to overcome that deficiency, we have retrieved the call detail records. Now, why is, seizure of a cell phone important or necessary? See, in case there is no clear-cut eyewitness account of a person seeing the accused, crushing the farmers, then the cell phone or the call detail records actually ensures or confirms, establishes their presence at the site.
Right.
So these are technical evidences which need to be collected, gathered to support the circumstantial evidence in any police investigation. Now, this is something which was pointed out by the court. If you do not establish technically, through technical evidence, the presence of the accused at the site or at the spot, then tomorrow during the trial, the accused can always raise it as a defense by showing, the presence of his cell phone somewhere else, to say that I was not even present at the site. So these are the kind of technical glitches that are still there in the police probe, the gaps which the court is actually trying to cover up by continuously telling the police that this is how you're supposed to kind of gather evidence. I think, honestly, this should have been part of the police probe.
Correct.
This is something which courts need not tell the police.
Should not have to do.
That's right.
Right.
Yeah.
Okay, this is from Hitesh, who's a member of the Print YouTube community. His question is actually related to the Upar fire tragedy
Okay.
and the judgment of the court. He just wants to know a little bit about the case and whether the Supreme Court should also rethink its decision on Upar.
So honestly, I haven't gone through the judgment yet, but I can just tell you one thing, that this case was related to tampering of evidence, because there were certain documents that went missing in the main case where the Ansar brothers were convicted, but they were not convicted for a very long duration. So after so many years in that particular case, and actually this tampering was done in collusion with the court employee. So that court employee was of course terminated from service, but a criminal case was started against the Ansar brothers, in which they have been found guilty, and now today they have been sent to jail for 7 years. Yeah. And as far as the first case is concerned, which was related to the fire, the Upahar tragedy, I think as far as all the legal remedies in that matter is concerned, they have been availed, and the Supreme Court has upheld its verdict even in the curative petition. So I don't think the court will now actually revisit it.
Right. All right, this question is from Ritika. In cases where the Supreme Court appoints a committee, what is the role of the committee in terms of responding to the Supreme Court? Essentially, how is the committee held accountable?
No, so since this committee, or any committee for that matter, is usually headed by a retired judge of a particular high court or of any high court, and being part of the judiciary, they understand their responsibility and duty towards the judiciary. And then usually what happens is, Ruhi, that most of the times the committee, they kind of submit whatever the findings have been in a particular case, they submit it to the court. But in this particular case, the role is very different. In this, we'll have to see what the order is on Friday, but from what I gathered today, in this committee, as far as this case is concerned, this committee will actually monitor the progress of the police investigation, So they may not have to submit any report directly to the court, but they will just make sure, the committee will just make sure that the progress is on the right track.
But will there be a timeline for the probe? Because then
I'm sure there will be. I'm sure there will be. See, there has to be a timeline for the probe for the simple reason that the charge sheet has to be filed within a stipulated time period as per the Criminal Procedure Code. If it is not done, then the accused will be out on jail, out on bail. Then they would be entitled to statutory bail, which means that if the police does not file a charge sheet within 90 days of filing of the FIR, then the accused can always ask for bail in default.
Right.
So it has to be a time-bound probe. It cannot go beyond 90 days.
Right.
Yeah.
So Bhadra, in a case like this where there is a lot of politics also involved, and this is, as you mentioned, it's not an ordinary case. We're talking, the main accused is the son of a minister in the central government. How much does the court's intervention help in keeping the pressure on in this case, the Yogi Adityanath government, and how much does it help in accountability? Because at the end of the day, otherwise there's nobody to hold that government accountable.
True. See, I think this aspect is very clear in the court's mind, and that is why when the hearing was going on, the Chief Justice very categorically said that we do not want any political overtones in the matter, and this is the reason why we want to have an independent committee to infuse independence and fairness in the probe. Ruhi, from today's hearing, I would just say one thing, that I think UP government today was very candid about the situation and about the problems that they are, facing, because Mr. Harish Salve candidly admitted that there have been people who have approached the police, people have actually approached the police in large numbers, to come out in support of the main accused.
Right.
And probably that is the reason why they have not yet recorded the statement of all the witnesses. So I think somewhere down the line, the UP government knows that it is under supervision. It is under the scrutiny of the Supreme Court. And I think that is why it is being very careful about the way it is moving on with the probe. See, with regard to the CCTV footage also, they're really following up with the, with the agencies that need to give them the forensic evidence along with the certificate. So they've written to the labs, and the lab has promised to send them the report within the next 15 days with regard to the CCTV footage and the call detail records. Usually in such cases, we have seen that the charge sheet is filed without these papers, without these documents. And most of the time, this actually comes to the benefit of the accused. So somewhere, they know that they're under scrutiny, under judicial scrutiny. So I think they are, they are kind of moving ahead very cautiously. And they're making sure that all the gaps, all the loopholes that are pointed out by the court are kind of covered up. So I think this kind of since it's a high profile case, that is why we've seen the judicial intervention. But these kind of technical glitches and technical gaps in police investigation is very common, because we have seen it even in the Delhi riots case, So, of course, some sort of pressure needs to be built up, at least to bring,
some accountability.
Some accountability, yes.
Right. Yeah. All right. So the Supreme Court continuing to build pressure on the BJP government in Uttar Pradesh to ensure a free, fair probe into the Lakhimpur Kheri violence, and Bhadra helping us understand how the court is doing that. Thank you for watching Government Matters and for sending in your questions. Keep subscribing to the Print YouTube channel.